New Delhi, and this is based on the interest on claim. I'll ask this. I'll ask you about this whether interest is allowed or not. If FC or OC filed his claim before IRP or RP, and there is no contract about the interest, but he is claiming interest on the basis of Interest Act. Just one minute. He is claiming interest on the basis of Interest Act under Section 3, because Interest Act is a general clause which permits to grant court or quasi-judicial body to allow the interest on the claim in case of delayed payment. So here, one claimant filed claim before the RP, and he is claiming that his claim should be allowed along with the interest. So I'm asking you whether RP or IRP is duty bound to add his interest on claim. Ashok ji.
Well, that operational creditor was an MSME unit, or it also depends whether
Any whether MSME or non MSME.
and there was not any specific contract between the corporate debtor and him.
Yeah, correct. So if there is no specific contract, then it is not permitted. Let me discuss about the reason given by the enclate. Just a moment.
Sir, if it has been mentioned in the invoice, that interest will be charged?
No, just I'll discuss about the relevant paras of the enclate judgment order.
Right, sir.
Is it visible? This is Capriso Finance Limited versus Trishul Dreams. Can you see the screen?
Yes, sir.
Yes,
Yes,
sir. Yes, sir. Visible.
Thank you. See here, I have highlighted for the for your each purpose. This the resolution RP has accepted the claim of appellant financial creditor but has not allowed the interest. The appeal was filed by the claimant. Counsel for the appellant challenging the order submit that the under Interest Act, the entitlement is there, although he submit that no documents could be filed for claiming the interest. Section 3 of the Interest Act on which reliance is placed is as follows. Power of court to allow the interest in any proceeding for the recovery of any debts or damages, or in any proceeding in which a claim for interest in respect of any debts or damages already paid is made. The court may, if it think fit, allow the interest to the person entitled to the debts or damages, or to the person making such claim, as the case may be, at a rate not exceeding the current rate of interest for the whole or part of the following period. तो ये period सारा दिया हुआ, all these proceed like during the pendency of litigation, during the dispute, all periods will be accumulated for calculating the interest. But now I'll come to main points. So these interests are allowed in case of negotiable instrument. Also, the compensation recoveries for the dishonor of bills or promissory note checks defined negotiable. Now, this interest will not be applied here under 138. If any case is pending before court or magistrate, then interest will not be allowed on negotiable instrument act matters. But in other civil matters, other recovery matters, interest is allowed. Here, there cannot be any dispute to statutory provisions of Section 3, which empowers the court to allow the interest. In the present case, it was the resolution professional who had to collect the claims and allow the interest. Present was not a case where Section 3 is applicable, and it was only a claim to be admitted in the CRP process. Hence, reliance on Section 3 is misplaced. We are of the view that no error has been committed by the AA. Appeal is dismissed. So, RP, the duty of RP is, just a moment. duty or responsibility of RP is to collate the claim and prepare the list of creditors. RP cannot add claim without contract. If there is a specific contract, then he can add the claim interest along with the claim. Whereas liquidator has power, because liquidator is here it is not mentioned, but I am telling from my knowledge that because liquidator is a quasi-judicial body. So liquidator has to look into the other aspects also, whether interest documents are there or not. Court can also allow. If there is no contract between the parties about the interest, in case of delayed payment, whether interest is allowed or not, court can allow under Interest Act. But RP or IRP is not the court or not the quasi-judicial body. Is this clear? So we will take one by one small cases so that you can also remember while collecting the claims, admitting the claims. Now I'll take second judgment, second matter relating to Section 9 application. This application was filed on the basis of bogus invoices, and the bogus invoices was pointed out in the assessment order. Just see, I'll share the judgment directly. Principal Bench, New Delhi, dated 5/9/2024. NV Aluminium Cast versus APL Metals. This appeal, just more. Appellate Tribunal, sorry, this is Appellate Tribunal of New Delhi. This appeal has been filed against order dated 23rd January 2024, passed by NCLT Kolkata bench. Section 9 application was filed. Section 9 application was rejected. AA in the impugned order has returned the following finding. Thus, in terms of the IT assessment order dated 38 December 2022 and submission made by the Learned Council, we would infer that the claims of the operational creditor filed in this application based on the bills is disputed by the IT department itself, and there is no stay order on the assessment order 38 December 2022. So even the claim has been filed on the basis of claim has been filed, and if IT department has disputed, then it will be treated as a disputed claim. Then again, the IT department, this is the finding from the above incident report. It was ample clear that the entities against which the incident report have been generated by the DGGIL Kolkata were in bogus billing, and hence APL Metals Limited was found reporting purchase from these entities. The same are also bogus. Even for the financial year 2021-22, as recorded in the IT assessment order, more than 67% of the sales made by the operational creditor to the corporate debtor is bogus, which is also contended by the AR of the OC. The OC has not been able to conclusively prove that defaulted invoices are not the bogus invoices. It appears that the application has been filed under Section 9 of the IBC based on bogus and disputed invoices raised by the Learned Assistant Commissioner of Income Tax, Kolkata. Thus, the application is a frivolous and hypothetical one with the malicious intent for any purpose other than for the resolution of insolvency. Hence, we are of the considered view that to prevent the parties from coming up with such an application, we feel it appropriate to impose penalty by invoking the provisions of Section 65. So, NCLT imposed penalty of ₹1 lakh upon the applicant. Adjudicating authority has held that no reliance can be placed on the invoices which has been relied by the OC, since the income tax authority has found the invoices are as bogus. Now, this was the finding of the NCLT Kolkata. It was challenged before the NCLT and the finding of the NCLAT is here. Hence, the finding are now reaffirmed that invoices which are bogus could not be relied upon for initiating insolvency proceeding against the CD. We thus are of the view that no grounds have been made out to interfere with the order rejecting Section 9 application. However, rejection of Section 9 application shall not preclude the appellant to take such remedy in the law as available. So, appellant is having remedy in other. He can approach to civil court for recovery of his due. But NCLT is not the adjudicating authority for deciding whether invoices are bogus, genuine. He has to look into the prima facie whether the debts or claims are disputed or not. So here, in fact, the present case, we are of the view that the imposition of cost in paranoid deserves to be deleted. So here, NCLAT had given just relief that cost was removed and appeal has been dismissed. So this was the finding of the NCLAT. Now,
Sir, a small clarification, sir.
Yeah, please.
In fact, the income tax authority has declared these are bogus invoices.
Correct.
Logically, how this person will apply under a different law, sir? A small doubt, though it is not directly related to this.
Because before trial court, appellant will have opportunity to prove whether it is disputed, bogus or genuine. So trial court, there will be trial, there will be a cross-examination of the witness before the civil court. But here cross-examination is not permitted. NCLT is quasi-judicial body and it is not the trial court. It is a summary court.
Achha, a small further discussion in worst case, if a trial court or civil court proves that it is not a bogus, then how the income tax authority findings and the civil court findings will be maybe how these will be considered, sir?
Correct. Your question is very valid. If civil court finds that the invoices are genuine, then he will decree the claims. He will pass the order in favor of the plaintiff.
Yes, sir. Operation creditor.
Yeah. But unless there is a decree, OC cannot approach NCLT. Because genuineness has to be decided first.
No, actually, probably this income tax authorities might have verified everything and they might have. That's why this person.
The income tax department might have verified. Income tax department there it is not necessary that a cross examination has taken place. They have given ample of opportunity to the OC whether the invoices are genuine or bogus. So here just prima facie he might have found that the invoices are bogus and passed the assessment order.
No,
There is an opportunity he can approach the appellate tribunal also. So before approaching appellate tribunal, in their income tax appellate tribunal, he just filed Section 9 application.
Correct. Actually, this order was passed based on the income tax assessment finalized on the 30th, probably December 2022.
It is not mentioned whether it is a claim has been filed on the basis of income tax assessment. The opposite party, the corporate debtors council might have brought some this.
Correct, sir. Correct. If the person, if the operational creditor might have submitted an appeal before income tax appellate tribunal, then probably he might have disclosed before this appellate court that I have filed appeal, but you cannot take this as a stand that he can take, no, sir?
Correct. But it is not mentioned in the order whether he has to appellate authority or not. It is not mentioned in the order.
He might not have appealed before appellate tribunal.
Yeah, so because NCLT has to look into whether it is a disputed claim or admitted claim. If it is admitted, he will simply admit. Otherwise, reject it. That's it. NCLT is not the trial court.
Okay, sir. Proceed, sir.
Thank you. Now, third judgments we will discuss, which is also pertains to this month only, September 2024, regarding personal guarantors matter. I ask you one question. If any personal guarantor dies, whether proceeding can be initiated against the LR, legal representative. Can
Yes,
anybody?
sir.
Yes.
Yes, sir, section 95, I think.
Okay.
No, 126, I think.
Ankit ji, Ankit Agarwal ji, whether section 95 proceedings can be initiated against LR, legal representative or legal heirs of the PG, personal guarantor. Santanu ji. Naresh.
Mr. Ajay, I think there is a recent judgment by Supreme Court in the case of deceased PG, the legal proceedings cannot be initiated against the legal heirs.
You are right. So we will discuss about this case law so that other participants can also be aware about the findings of the Supreme Court. This is very important judgment.
Sir, previously, I think that there was a provision in IBC. There was a legal proceedings can be initiated against a dead person also in IBC.
No.
There was a section in IBC.
I am coming to only 95 application, personal guarantor matter right now.
Sir.
I am discussing about this judgment of NCLT Bench 4, New Delhi. And this matter is between Apogee Enterprises Private Limited versus late Sri Anil Nanda. Anil Nanda is the personal guarantor here. So he expired during the pendency. Just come to the interim application has been filed under Rule 53. Read with Rule 11. Rule 11 of NCLT is Rule 11 gives inherent power to NCLT to pass any order for the end of the justice. So praying for substitution of legal heirs or representative of the respondent in CP number so and so. So CP was filed in 2020. The company petition against the PG was filed in 2020. During the pendency of the proceeding of CP, this PG expired. The personal guarantor expired. So this application has been filed to implead LR in this matter. Now, I'll read this second para. It is the case of the applicant that the applicant has filed CP number so-and-so under section 95 against the personal guarantor. Personal guarantor against whom insolvency proceeding was filed has passed away by way of present IA. The applicant has sought substitution of legal heirs of the personal guarantor in place of personal guarantor who is no more alive. This is very important orders and we must know about this thing. Heard the London Council on behalf of the client, we have perused the contents of the application, the written submission filed by the applicant. The issue which arises for our consideration is whether insolvency proceedings under Part 3 of IBC abate upon the death of the guarantor, or can the proceedings continues against the LR of the deceased guarantor. LR means legal representative. The Learned Counsel on behalf of the applicant has relied upon the provisions of section 123 and 169 of the IBC. He has also relied upon the section 17 of the Provincial Insolvency Act. In Provincial Insolvency Act 1920, there is a provision that LR can be impleaded, and judgment of the Honorable Allahabad High Court in Molhar Singh versus Raghunath, SCC 1972. The issue as to whether upon death of the personal guarantor, proceedings initiated under IBC Part 3 shall abate or not has been considered previously by NCLT. The principal bench of NCLT in Alchemist Assets Reconstruction Company versus Deepak Puri, Wide Order 1811-2021 has held as under. It has been rightly pointed out that in case of proceedings under section 95 of IBC, it is the case for initiation of insolvency resolution process against the personal guarantor, and it is not a case of recovery of amount, because that will go contrary to the scheme of the IBC. See the reason, the logic which has been given by the NCLT in this alchemist case, that this court or IBC proceeding is for the purpose of resolution. It is not for the purpose of recovery. In civil court, you can implead LR, legal heirs, son, brother, wife, you can implead any legal heir. But here it is not the recovery, it is the resolution process proceeding. IBC is the resolution process, basically. Insolvency. So the logic given by the NCLT here, so it is not the recovery of any amount, because that will go contrary to the IBC in such situation on the demise of the personal guarantor and individual who has given his guarantee in the favor of the corporate debtor. The question of continuing the proceeding against such a dead person will not arise. So proceeding will abate. Is this clear? Since the proceeding abate, section 95 has also to be closed. Kolkata bench NCLT. However, there in Kolkata bench NCLT 2021 also held. However, there is no provisions in the code. The provisions, the code is also silent. While drafting the section 95, the legislature, I think, forgot to give clarification in this provision that it is only to the personal guarantor, not for the LR. So there is no clarification, though no explanation given in section 95. So however, there is no provisions of the in the code which envisages that the concept of legal heirs steps into the shoes of the deceased personal guarantor. Therefore, we hold that instant application cannot be maintained against the legal heirs or of the personal guarantor under the code. After relying upon the aforementioned judgment, the NCLT bench 6 of the New Delhi in the matter of Bank of Maharashtra versus Ashok Kumar Bansal, in their judgment dated 21st November 2022, dismissed the petition filed under section 95 on the death of the personal guarantor. In the present case in hand, the application under section 9 has been filed by the applicant for initiation of insolvency resolution process against the PG, who is now deceased. The term personal guarantor has also been defined under section 5 subsection 22 of the IBC. Personal guarantor means an individual who is the surety in a contract of guarantee to a corporate debtors. So he is the surety under section 128 of the Contract Act also. The Honorable Supreme Court in the matter of Vinayak Purushottam 22 held that, but in the case of personal obligation imposed on a person under the contract and on the demise of such person, his estate does not become liable, and therefore the legal representative who represents the estates of the deceased would obviously not be liable and cannot be directed to discharge the contractual obligation of the deceased. So this was the finding of the Honorable Supreme Court. And based upon these judgments, now I come to the relevant para number 15. The applicant has also relied upon the judgment of the Honorable Allahabad High Court in so-and-so Molhar Singh case. The said judgment of the Allahabad High Court is in respect of provisions contained in section 17 of the Provincial Insolvency Act 1920 and not under the IBC. See, Allahabad High Court has allowed to implement the LR in the Provincial Insolvency Act, because that act is that act provides about the implement of the LR, but IBC doesn't. Therefore, the same is not applicable to the present case in the hand. In view of the above mentioned judgments and provisions of law, we do not find any merits in the application for substitution of legal representative of the deceased personal guarantor in the present proceeding. Thus, IA number so and so is dismissed without cost. Further, in view of the death of the personal guarantor, the case is closed, dismissed.
Sir,
Sir, a small query, sir.
sir, I have a query here.
Yeah.
Yeah, me also. Actually, the two provincial acts were already repealed, na, sir. How they can force after repealing those acts?
See, the applicant is relying upon the old statute, Provincial Insolvency Act 1922. In that act, there is a provisions for implement of LR, and that, on the basis of that provision, Allahabad High Court has allowed, but IBC is completely silent. And the logic, the judgment is based on the logic. The logic is given by the NCLT that it
No,
is
sir,
not
the
the recovery
act
court.
was, sir, no, the act was not in force. How they can, how could allow the petition? Because the act was in force, no? When the act was only force, they may have the right to file the petition. When the acts are
No,
repealed, yeah.
no. Sir, it is repealed, but it is the old judgment. He is relying upon the old judgment. The applicant
Okay.
relying upon
Yeah.
the old judgment. Sir, my lord, kindly see that Allahabad High Court has allowed. So the respondent in say that they have allowed on the basis of old judgment, old act. So
Okay.
old act has been repealed, and IBC is absolutely silent about this thing. IBC says only it is a resolution process. So NCLT has also given the same logic that it is the insolvency resolution process, not the recovery process. Therefore, I am not allowing to implead LR in this matter, and case is dismissed.
Sir, a
So,
small note, sir.
please.
I think I can give a
So-
small note. Though the provincial insolvency and other acts were repealed, but that was not implemented, sir, so far. Because the cases still in civil courts are filing under Provincial Insolvency Act.
I haven't seen such type of any case right now, because after repeal, I haven't seen.
Recently only we have filed one case, sir, one case in Hyderabad.
Kindly share if you have filed, if anybody has filed, kindly share with me. My email ID, I am just giving in chat box. My
Okay.
email ID. Just a moment.
Sir, recently, I want to give you a small qualification, sir. Regarding in Hyderabad, actually the two acts were repealing. Then the people are where to go to people. They approach to the High Court. The High Court has given one order, sir. Unless the Part 3 of Insolvency Act, whenever it comes until again the judicial has granted to the civil court, sir.
Yes, sir. Yes. Sir,
See,
actually, against the individuals, the DRT provisions are not in force now.
Yes, sir. That's why High Court has given a circular order. I think, sir, Mr.
Yes.
Shyam Krishna, sir, you stay in Hyderabad, sir? Are you
Yes,
staying in
sir. Yes,
Hyderabad,
sir.
sir?
Yes.
I to
Yes,
stay in
sir.
Hyderabad, sir. I to stay in Hyderabad. I belong to Hyderabad.
Oh, okay,
I
sir.
will,
Okay.
if it is possible, I will send you the order copy. Just you send me your number to me. Sir.
yeah, I have
Right,
just given my mobile number and my email ID.
Yes, sir. Yes, sir. Just you send me, sir. I
Okay.
will send you the copy.
Okay.
Okay.
So civil court can allow, because civil court has in recovery proceedings, in civil suit, in recovery suit, LR is allowed. They can file the case against the LR for recovery of the debts. But IBC doesn't allow. IBC is the insolvency resolution process mechanism.
కరెక్ట్ లేవు కదా ఇంకా
Whatever.
ఏది కాదు
Yeah, that might be only the object, sir. That's why under 95 they are not allowing, but under 123 they are allowing. See, when the resolution process failed and 123 comes into picture, then maybe this guarantor died during the course of bankruptcy, then definitely they will allow. There is a provision anyway.
So there is, that's just for just a moment. 123.
Yes,
I'll
sir.
read the
123(5).
Just a moment. Please share your contact number in chat box also. Mr. Syam,
Sir.
please share your contact number in chat box.
Okay, sir. Okay.
Application by the creditors. The application for bankruptcy by the creditor shall be accompanied by the records of insolvency resolution process undertaking, a copy of the order passed by the AA, details of the debts owed by the debtors to the creditor, such and other information, an application under made debt which secured the company, a statement by the creditor having the right to enforce the security, given the security benefits of the all creditors, a statement by the creditors stating that the application for bankruptcy is only in respect of the unsecured part of the debts and an estimated value of the unsecured part of the debts. If a secured creditor makes an application for bankruptcy and submits a statement under section so and so, under subsection so and so, the secured creditor and unsecured part of the debts shall be treated as separate debts. The creditors, subsection 4.
Go to 5, sir.
The creditors may propose an insolvency proposal professional for bankruptcy application. An application for bankruptcy under subsection 1 in case of deceased debtor may be filed against the LR. So this is the contradictory. See, 95, these provisions has not been included in 95. The bankruptcy proceeding, actually bankruptcy proceeding is the recovery proceeding. Just try to understand.
Correct, sir, correct.
Bankruptcy proceeding is the recovery proceeding. And 95 is the insolvency, this 106,
Resolution process.
106, 106 or 102 is the resolution process.
Yes. That is only the object.
Yes, yes. Thank you for pointing out this 123 subsection 5.
5.
Now we will discuss another case. Fresh startup of CRP. This is again, this judgment is pertaining to 6th September 2024. 6th September 2024.
Sir, please display, sir.
Yeah, sure. This judgment is of Mumbai NCLT. Darwin Platform Infrastructure Limited applicant, and there are all these 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. All these are FC or member of the COC. Just a minute. This CRP was initiated against this CD. The CD name is Lausa. I'm just telling the first name only. There are, because four CDs are there in this matter. So first CRP was initiated against Lavasa under section 9 on 30th August 2018. 30th August 2018. The CRP was initiated against Lausa. Just I'm coming to only relevant paras so that see what is the prayer before this NCLT? IA number so is filed before Darwin, filed by the Darwin infrastructure applicant. Applicant is the SRA. Here applicant is the SRA under section 60 and with section 74. Seeking the tribunal be pleased to order and declare that the invocation and encashment of PVG, Performance Bank Guarantee, by Union Bank of India, white letter note, is bad in law, illegal. The PVG was encashed by the FC. Direct the respondent number 1 to return 25 crore rupees 25 crore to ICICI Bank and declare that upon such return, this said PVG continues to be valid and binding. Pass an appropriate order for punishment of respondent number 1 for violating the violation of section 74. Do you know what section 74? Section 74 is the penal provisions for violation of moratorium. In case of violation of moratorium, section 74 will come into play. So here, and they pass an appropriate direction to the respondent, so exclude an overall period of 90 days. These issues or these prayers were part of the application. Now come to the main issues before this NCLT. Another IA was also filed seeking following review. Restore the CD back to the corporate insolvency process and appoint erstwhile RP, Mr. Saleson. Exclude the period of from 13 July 2021 to 3rd January 2022. Direct for dissolution of the monitoring committee, allow the utilization of 25 crores, which was encashed through PVG. Now come to background. That the Raj Infrastructure Development filed Section 9 application against Lavasa. It was the LCL, Lavasa Corporation Limited. The said application was admitted on 30th August 2028, and thereafter CRP was initiated. Another CRP was initiated against WAML. Third CRP was initiated against just a moment. Haldiram, Mr. In the meantime, on an application of the COC of LCS, Lavasa, the CRP process against WAML and DCL were consolidated with the CRP. See, all these companies are system concerned. Some companies are subsidiary to the Lavasa. So all these CRP was consolidated. This is a very unique case where 4 CRP were consolidated. And the resolution plan which was filed by the COC, filed by the this applicant was accepted by the COC. However, the SRA failed to meet the requirement of the failed to pay the committed amount as per the resolution plan. So I'll come to the main para here. Just this is the brief facts of the matter, that the four CRPs were consolidated and para number 6, 13 December the COC approved the resolution plan filed by the so-and-so, 96% voting, right? Now come to order so-and-so plan approval orders, resolution plan, and monitoring committee was also appointed, constituted on 25th July 2023. After approval of resolution plan through the monitoring committee was constituted on 25th July, the implementation of resolution plan has been encountered various challenges. Now see what was the challenges. The status of the CD was reflected as an active non-compliant on the record of MCA. in order to undertake any further steps toward the implementation of the resolution plan, such a fresh issuance of the reorganization of share capital, it was necessary for the CD to active compliant. For the purpose of CD, I will come to para number B. After approval of resolution plan, this tribunal, Union Bank of India, filed an application number so for recall of the plan approval order on the ground that it is nationalized bank that has been made to suffer a haircut nearly 80%, which is grossly inequitable and unpalatable, considering the fact that the public money is involved. Respondent number 1 further pleaded the various reports of the assets of the CD were obtained in the year 2000 valuation report pertaining to 2018, whereas the plan was approved in 2023. See, the plan was approved in 2023 and the valuation and all these things were disclosed on the basis of valuation report, which is pertaining to 5 years old valuation report, 2018. There was a drastic changes in the valuation and this aspect was also overlooked while approving the resolution plan. The aforesaid IA was dismissed by the tribunal, order dated so 23, against which respondent number 1 preferred an appeal in 2023 before enclave, which was also dismissed by the enclave only on 10th January 2024. Similarly, after the plan approval order, SBI, another secured creditor, filed an appeal which was also dismissed. Various other parties losses also raised the objection and initiated litigation. The pending litigation include the litigation initiated by the respondent number 1. So I'll come to the relevant para again. Submission of the applicant, Union Bank of India. Here, the applicant has summarized the discussion and resolution passed in the various MC monitoring committee. The first meeting so and so was decided inter alia to effective. Reply filed by respondent. C. Analysis and finding. We have considered the common facts taken by both the applicants together and heard the learned counsel for both the applicants and the respondents therein. We have also gone through the records carefully. The facts of the case reveals that resolution plan submitted by the SRA got a muster of 96.41% majority of COC and was subsequently approved by the tribunal by plan approval order. As per approved resolution plan, the SRA was required to make an upfront payment of 100 crore within 90 days from the effective date, the date of approval of the resolution plan, and receipt of copy of order, and the payment of further amount of rupees 50 crores within 9 months from the effective date. The amount under the resolution plan are to be utilized for meeting the CRP payment to certain creditors, including secured creditors, and also for meeting the working capital, etc. In addition, all cost expenses incurred by the MC, including fees, etc. The resolution plan also provides that post-approval resolution plan by NCLT, all costs incurred in relating to implementation of resolution plan and litigations, if any, connected with CRP of this CD, ongoing litigation, including legal cost, which is to be incurred by erstwhile RP, MC, /MC, shall also be borne by the CD. The applicant under the resolution plan has undertaken to maintain a reserve of rupees 50 lakhs till the 15th months from the effective date or payment of the first tranche, whichever is earlier, for payment of legal cost in an interest-bearing escrow account to be maintained with designated pack. MC, the monitoring committee as per the resolution plan was constituted on 25th July 2023 and held 7 meetings for implementation of resolution plan. However, much progress could not be achieved in implementation of resolution plan, resulting in the invocation of PVG of rupees 25 crores furnished by SRA. This led to filing the present application. So MC taken the view that the SRA failed to fulfill its obligation, so they encashed the bank guarantee of 25 crores. Upon consideration of the revival submission, the following issues arises for our consideration in this application: whether invocation of PBG is legal or illegal, legal or proper, whether an extension of timelines for implementation of approved resolution plan should be granted. In the event of non-extension of time for implementation of resolution plan, can CRP be restored? As to what relief, if any, the applicant are entitled to. See, after 3, 4 years, 5 years, the CRP initiated in 2018. In 2023, these questions arises whether CRP should be restored. So back to square after 5 years. CRP period is only 180 days. So after 5 years, these issues came before the NCLT. So RP is still continued with this this matter. The primary contention of SRA is that the status of the CD was reflected as an active non-compliant in record of MCA, hence no further steps such as fresh issuance of reorganization capital. These are not the relevant parts here. On the contrary, the respondent have contended that upfront payment of 100 crore was to be crores to be made by the applicant within 90 days for effective date as per the approved resolution plan is no way linked to the formation of new board of directors or achieving the status of the active compliant status of the CD.
Yes.
I think this para should be read. The primary contention of the SRA is taking defense that my PVG was invoked illegally. So he is taking defense. The status of the CD was reflected as non-compliant in the record of MCA. Hence, no further steps such as fresh issuance of reorganization of share capital, etc. could be taken for raising the funds. For raising the funds, SRA will have to approach the financier or bank. He will show that I have purchased this CD through NCLT, so please fund me. So SRA has taken the stand before funder or before the lender that company is showing non-compliant, non-active. How can I give you fund? His stand is also correct. The change of status of active complaint require the filing of audited financial statement. So while you borrow the funds from the bank or financial institution, they also ask the audited balance sheet, active company. All these things were not in place. So his points are very, very valid. The points or the objection taken by the successful resolution applicant is very valid, that company is non-compliant and this audited financial statements are also not available, and all these things are required for constitution of board of directors and undertaking of the other seat. The discussion in MC on the agenda items approving the company secretary for achieving the active complaint status remained inconclusive, which is a major reason for non-implementation of the resolution plan. So non-implementation of resolution plan, the ground taken by the SR is absolutely valid. Nobody will give fund for non-compliant company. If audited balance sheets are also not available, nobody will give funds. But here, see the logic or the reason given by the NCLT. The part A of the resolution plan, which deals with the financial structure, specifies the payment schedule and the source of funding. Further, the resolution plan provides a management and control of the business of the CD during the resolution term. Board of directors approval so will be treated as order. What happens after implementation of resolution plan? The old board of directors retires, new board of directors enters. The board of directors will take over the management responsibilities of the company for better operation on payment of upfront amount of rupees 25 crores within 90 days of the effective date. Till the upfront payment is made, monitoring committee will be having all the powers of the board to monitor the operation of the business. The resolution applicant will appoint requisite directors as required under the law, who may be executive or non-executive directors. Access to the site monitoring committee. Now come to the main para. In this connection, it is noticed that the third addendum to the resolution plan modified the definition of upfront amount or upfront payment as amount of rupees 100 crores proposed to be paid by the resolution applicant within 90 days of the effective date in terms of the resolution plan, but other terms referred to hence herein above remained the same. A plain reading of the aforesaid provisions in the resolution plan makes it abundantly clear that upfront payment was required to be made within 90 days from the effective date of such payment, was not linked or subject to any other condition. So upfront payment was unconditional. In nutshell, the upfront payment was unconditional. The Council for the Union Bank of India, representing the secured financial creditors, has brought to our notice the order passed by the enclave in the matter of PKH Venture Limited versus MC of Amar Remedies. Clause 5 was sourcing of funds, and the payment schedule and conditions and the timeline for payment were not dependent on or conditional to sourcing of fund. In the event the funds are not provided as per clause 5 subclause C, the plan has to fail. The implementation of plan being not dependent on sourcing of funds, because sourcing of funds was the responsibility of the RA, and decision applicant cannot be heard on the contending that since the status of the company was not changed into the active, he cannot infuse the fund and make the payment. The plan was approved on 25th March 2021 and is in 3 years, no payment was made as per the resolution plan. So what stand has been taken? The implementation of the resolution plan being not dependent on the sourcing of fund. See, the SRA cannot take the excuse that the sourcing, I will arrange the fund, I will source the fund. He has to keep all these things ready. He cannot take a stand that because I could not arrange the funds. If he is entering into contract, it means he is ready with the funds. He is ready and willing to invest within the timelines. So this stand was taken, and Clayt has given this finding in its judgment. Now the Council for the SRA has filed a written submission to distinguish the decision on the fact. However, we are of the view that the above decision is squarely applicable to the facts of the present case, for the reason that the payment terms under the resolution plan are unconditional in this case also, and are not single payment as per or under the resolution plan has been made. It is pertinent to observe that though the representative of the SRA was present in all meetings of the MC, he never informed the MC that payment of upfront amount was delayed on account of inactive status. See, SRA was also silent. He never informed. He should have informed. I have told in the earlier, I had also conducted, I'll just take a pause here. I had also taken one session of this anatomy of case law earlier, about 6-8 months back, where I have pointed out that in my first class, when I attended the LLB first class, lecturer taught me first lesson. Please listen carefully. Lecturer taught me first lesson that law does not help to lazy person. Please keep in your mind, please write in your diary, law does not help to lazy person. If you are active, even if, see, if you are not, if you have not done any work, doesn't make any difference. Law will help you, but you must be active, you must be compliant. Here, SRA did not inform to monitoring committee that since the company is not active, so I am unable to arrange the fund. He should have informed. So I recall this thing memory that the law does not help to lazy person here. See, 25 crores is a very big amount, and his 25 crore has been wasted completely. It has been encashed by the bank and it has been forfeited. So because we are professional, we are advocate, IPs, so we should be always active. Whenever we receive any notice, whenever we find any difficulties in CRP or liquidation process, we must record in this our email or minutes or notice everywhere, so that tomorrow COC or IBBI or NCLT cannot point out that you have not done this thing, you have not taken any action, you have not complied. So we must be very careful. And sometimes what happens, I have seen the IRP or RP delegate some work to his junior, which is true, which is correct, but ultimately responsibilities lies upon the RP. So even if you have delegated some work to IPE or your juniors, okay, but you have to check all documents, whether all draftings, whether he has drafted everything in line with in compliance with the law or not. You cannot take excuse that my junior has drafted all these things and there was some mistakes. I am sorry. You cannot take any excuse. So now I'm coming to again the same judgments. It is pertinent to observe that though the representative of SRA was present in the all meeting MC, he never informed the MC that payment of the upfront amount was delayed on account of inactive status of the CD, despite the insistence of other members of MC, monitoring committee, to make upfront payment. Thus, SRA, successful resolution applicant, SRA, just appears to be making lame excuses for not making the upfront payment as stipulated in the plan. Another contention raised by the SRA is that the litigation initiated by respondent number one is Union Bank, who has encashed the bank guarantee. Bank guarantee was given by the ICICI Bank. Sorry, bank guarantee was given by the SRA through ICICI Bank in favor of the COC. So COC, this Union Bank has encashed in bank guarantee here. The another contention raised by the SRA is that the litigation initiated by the respondent number one for recall of the plan approval order and the appeal filed by the respondent number two against the plan approval order exposed the applicant to a greater risk and deterred him from making payment. This created a climate of considerable uncertainty for the applicant, and it could not be expected to pay those creditors who had proceeded to challenge the resolution plan itself. So somebody has also challenged the resolution plan here. Now come to third para. On the other hand, learned counsel for the respondent has contended that litigation against the order approving the resolution plan are common, and in absence of any order of the court or tribunal staying the resolution plan, there cannot be any reason or justification not to implement the approved resolution plan. There was in fact nothing to hinder or stop SRA from carrying out the implementation of resolution plan, and pending litigations are common in such proceeding. However, in the absence of any order of the court staying the resolution plan, SRA has no reasons not to implement it. It was further noted by the lenders that in case SRA continued not to implement the resolution plan, the natural consequence of the forfeiture of the PBG was found to follow. Now come to next. Now effective part of the order, I'll just read. based on the considered majority lenders of Before we consider the above rivals contention, we may notice regulation 36B sub-regulation 4A of the CRP regulation. The request for resolution plan shall require the resolution applicant in case its resolution plan is approved under subsection 4 of section 30 to provide a performance security within the time specified therein, and such performance security shall stand forfeited if the resolution applicant of such plan after its approval by the adjudicating authority fails to implement or contributes to the failure of implementation of that plan in accordance with the terms of the plan and its implementation schedule. So law is very much clear. In case of SRA fails to implement, security amount will be forfeited as per this regulation 36 subsection 4A. It is very much clear. The use of word fails to implement or contribute to failure of the implementation of that plan in accordance with the terms of the plan and its implementation schedule shows that even contribution to the failure of the implementation of the plan should be sufficient to invoke the PBG, performance security. Further, clause 1.9 of the RFRP provides that request for resolution plan, RFRP 1.9 clause provides Union Bank of India in its capacity as a member of COC shall have the right to invoke or encash or forfeit the performance security by issuance of a written demand to invoke performance security or by encashing the demand draft as the case may be. The performance security can be invoked or encashed forfeited at any time if so failure of successful resolution applicant to implement the approved resolution plan in accordance with the terms of the case, in case the successful resolution applicant contributes to failure of implementation of the approved resolution plan in accordance with the terms of the approved resolution plan and its implementation schedule after approval of the resolution plan has been provided by the adjudicating authority. Now
Approved by this, sir.
Provided by the adjudicating authority. Just a moment. The fact that the Union Bank of India is currently not part of the MC has no bearing on the capacity of the PBG. The letter now come to the. It is pertinent to observe that SRA not only failed to make upfront payment as required under the approved resolution plan, but also failed to take any real steps even after the dismissal of the appeal by the unclaimed. The appeal was dismissed on 10th January 2024. And 13th February 2024 appeal filed by the SBI. The PBG was invoked by the Union Bank on 8/4/2024. So same formula comes into play. Syamji, same formula. Law does not help to
Lazy people.
yes. The stake is very high, 25 crores. And see, the appeal was dismissed, but he has not taken any step. He was just sleeping. If he would have taken some steps, then he could have some remedies before the court. So this clearly demonstrates that the SRA was never ready to implement the resolution plan. See, SRA has to demonstrate before the court that he is ready and willing to implement the resolution plan with the supporting evidence. Merely making the statement before the court that I am ready and willing to implement the resolution plan will not serve the purpose unless some documentary evidences are there. So this will help you while conducting CRP. You will have all these things in your mind. If SRA commit default, you can immediately point out to MC or COC and then NCLT that these things have been taken place, and due to which you can invoke the bank guarantee. This clearly demonstrates in the light of the discussion, we have no hesitation in holding that SRA was starkly contributed to the failure of implementation of the approved resolution plan in accordance with the terms of the approved resolution plan. Consequently, Union Bank has rightly invoked and encashed the PBG furnished by SRA, and the proceeds thereof can be used for the purpose as decided by the COC. So, COC or this RP got additional fund of 25 crores by encashing the bank guarantee. So, complete fund has been forfeited. The SRA, but see, the main point is the purpose is not the forfeit, purpose is not the encash the purpose of the CRP is to resolution of the debts of the CD. The SRA has submitted that it is ready and willing to implement the resolution plan and sought an appropriate direction to the respondents. It is for in support of the SRA relied upon the judgment of enclate, whereby jurisdiction of tribunal to extend the timelines under the plan affirmed. It has also been affirmed that the extension of timelines does not amount to modification of the plan. See, jurisdiction, the NCLT has jurisdiction to extend the timelines also. But if SRA fails to implement the resolution plan, then without any giving good reasons or basic reasons, NCLT will not extend the timeline. There is no dispute that with regards to the proposition of law laid down in the above cited case. However, our consideration here is limited to whether the present is a case of fit for extension of time. It is noticed that resolution plan was approved by this tribunal way back on 21st July 2023, about a year back. And even after 1 year, not a single positive action appears to have been taken by the SRA towards implementation of the plan. It is also pertinent to observe that even in the application, the SRA has not given any specific period for making this such upfront payment and remaining payment under the resolution plan, but also state that it is ready and willing to implement. So merely saying that I am ready and willing, it will not serve the purpose. You will have to show by the documentary evidence, yes, you have taken the effective steps for implementation of the resolution plan. Even if you make delayed in payment, no issue, no problem. But you will have to demonstrate by way of evidence. Now come to the concluding part here. Further, the council has relied upon the case of Almas Global Opportunity, where Enclate has upheld the NCLT decision on application made by the lenders directing restoration of CRP to this restoration of CD to CRP instead of pushing it into liquidation. So liquidation is the last resort. It is not the objective or it is not intention of the IBC legislation. The intention of the IBC legislation is the resolution. So CRP has been restored in this case also in Almas Global Opportunity. So another case in Committee of Creditors on Amtech Auto Limited, while observing that the said judgment does not lay down any proposition that when the implementation of resolution plan has failed, no other option is available except to direct the liquidation. It is therefore submitted that tribunal has the power and authority to restore the CRP of the CD to sustain it as a going concern. The purpose is going concern. Purpose is resolution. Even otherwise, as per scheme of the code, the resolution of the CD is the ultimate objective and liquidation of the CD is only a last resort. It is well settled and reiterated from time to time by the Honorable Supreme Court that all possible steps and efforts be made to revive the CD before opting for liquidation. Further, we further also observe that keeping in view the peculiar and distinct nature of CD and also keeping in view the large interest of the home buyers, all other stakeholders, the revival of the CD seems to be of utmost significance. Hence, the prayer to exclude the period from submission of plan 13th July 2021 till the filing of IA for approval of resolution plan, that is 3rd January 2022. So it means 6 months from CRP can favorably be considered in exercise of the incidental power under rule. So these periods have been excluded. 13th July 2022, almost 6 months. As a corollary to the following discussion, we found that SRA has miserably failed to take any positive action to implement the approved resolution plan without any justifiable reasons. No purpose would be served by granting further time to SRA for implementation of the resolution plan. Any further delay in resolution plan, CD would not only severely affected the interest of various stakeholders, but would also render the resolution impossible. Thus, the prayer of the SRA seeking the extension of time for implementation of the resolution plan is hereby rejected. We are further of the considered view that since the SRA is blatantly and consciously responsible for the failure of implementation of the approved resolution plan, its inevitable consequence is the invocation of PVG furnished by SRA. We therefore hold that the PVG has been rightly invoked and encashed by the Union Bank, and there is nothing illegal or improper in the same. Resultantly, the relief sought by SRA in its application cannot be granted. So, final order is this: the CRP of the CD is restored. Mr. Sailesh Verma as RP in the charge of CD, the period of 30 July to 3rd January 2022 excluded, shall stand excluded, and because the SRA failed to implement the resolution plan, and shall stand excluded having rendered redundant owing to the failure of the SRA in implementation of the resolution plan. Under these circumstances, the monitoring committee shall stand dissolved with immediate effect. So this is the reason judgment given by the
Mumbai bench.
Just a moment.
NCLT Mumbai.
NCLT
Mumbai, sir.
Yes, NCLT Mumbai.
But it's a very interesting and typical case, sir.
Yeah, and there are 4 CRPs concentrated in one case.
From the admission of CRP to the rejection of CRP plan.
Yeah, so back to square. And I have seen similar case, no, not similar, the facts are different and the situation is also some different, but in case of JNC construction, you must have heard this name of the case, JNC construction, Supreme Court restored the CRP after 5 years. No, it was commenced in 19, 20, 22, 23, 23. In 23, after 4 years. CRP restored after approval, after implementation of the resolution plan. Why? Because Greater Noida Authority was not part of the COC. RP failed to issue any notice of the COC to the Greater Noida. RP failed to point out NCLT during approval of resolution plan that Greater Noida is having more than 10% claim. RP failed to admit the claims of this Greater Noida. So Supreme Court has passed stricture against the RP also in Greater Noida case, in JNC construction case. If I will get time, I will share JNC construction also. But meanwhile, I will discuss another case. Now, small cases. Section 12A I ask you one question, whether section 12A applies in case of liquidation or not, during liquidation. My question to you, are you aware about section 12A?
Withdrawal of application by CDs.
Withdrawal
Sorry,
of,
creditors.
yeah, withdrawal of.
Yes. So whether section 12A applies during the period of liquidation?
Sir, here in the section 12A in the CIRP, the 90% of the COC voting is required, but whereas liquidation comes, whether the SEC, there is no SEC, no?
Your
There is no
logic
COC, no,
is,
there is no COC.
yeah, your logic is correct. In one of the case in Kolkata NCLT, I just remember Kolkata NCLT allowed withdrawal of CRP and liquidation both under section 12A.
Voting by?
Kolkata NCLT allowed the withdrawal of
Yes, sir. No, whatever, 90% voting by whom? The
SCC
stakeholder committee?
SCC.
Yeah. Yes. That's what I got also. Yeah.
But now Enclave has cleared this matter in the judgment of, in the case of, I'll just read the case. I'll share the case. See, I have not prepared what you call PPT, all these things.
PPT.
I am just strictly relying upon the wordings of the Enclave. I have not added any words, my words. Unlike other, like session, I have seen various persons prepare PPT and then put their observation. I have just relying
Directly you send this case last. Directly you share the case last.
Yes. Now I am coming to section 12A. Enclave. This brief was given by the IIP. So I am not reading the detailed judgment. The CRP of Messrs Hindustan Motors India Limited. It's a very big company. इसका ये वो भी था ना, क्या ना, प्रीमियर ऑटोमोबाइल और एम्बेसडर कार, आई थिंक Hind Motor, no, it's Hind Motors. This is different. Hind Motors India Private Limited CD was initiated by an order under section 10 of the IBC. You know section 10?
Yeah, application by the CD.
CD itself. Yeah, application by the CD itself. You are right.
Itself, yes.
Yeah. Thereafter, the A passed an order of liquidation. Application was filed by the depositors of the CD, appellant here, before the A under section 12A, seeking a direction to the liquidator to call the meeting of the COC and to consider the application filed under section 12A. A rejected the application filed by the appellant, holding that it is not maintainable. Additionally, they contended that liquidator proceeded with the sale of assets without constituting SCC, which they claim is required under the IBBI liquidation process, Second Amendment Regulation 2022. Agreed by the order passed by the A, appeal has been filed. I am just taking a pause here. During CRP or after CRP, you will find that I have encountered such kind of situation where suspended management approached me. I have also conducted 2-3 CRP, approached me during liquidation that no, we want to resolve all these things, debts, and we want to settle the debts of the banks, and we want to get this company back in my hand. I said it's not possible. So you will also find such kind of offer. So you can rely upon this judgment of Enclave. Okay. Honorable Enclave held that COC exists till the continuation of the CRP. Is it visible?
Yes, sir.
Okay. COC exists till the continuation of the CRP, and after the order passed under section 33 of the liquidation, the COC does not continue so as to take a decision for withdrawal of an application under section 7, 9 or 10. The statutory scheme of the IBC thus clearly contemplates that withdrawal of obligation is permissible only during CRP period. with the approval of 90% vote shares of the COC. The scheme of liquidation and liquidation regulation do not contemplate any withdrawal under Section 12A. Thus, in the liquidation process, compromise or arrangement is contemplated as Regulation 2B, which clearly negates the submission of the appellant that withdrawal is permissible only under Section 12A. In view of the clear statutory scheme as delineated by Section 12A, Section 33 and Regulation 2B of the liquidation regulation, we are of the view that during liquidation period, an application under Section 12A is not permissible. We are of the view that adjudicating authority for the reasons as noticed above did not commit any error in rejecting IA numbers also filed by the. So, COC does not exist. You can go for compromise arrangement under liquidation process regulation, but you cannot go under Section 12A, which is meant for CRP only. 12A is meant for only during the CRP. So the Enclave has given clear judgment, whereas Kolkata NCLT has given different contradictory judgment to this.
ఇప్పుడు కాదు అన్ని కావాలంటే ఇప్పుడు కాదు నేను అదే చెప్పబోయేది.
ఇప్పుడు ఏమంటుందంటే
Now it's 3:30. See, if you are ready, I will also give you some tips of the pranayam yoga, because I am yoga instructor. Not now, after about is agreed by the impugned order relating to the point number 3, which is about the inclusion of 15 months period calculating from while calculating the liquidator fees. देखिए लिक्विडेटर का फीस स्लैब के हिसाब से है, आप जितने जल्दी रियलाइज करोगे आपका परसेंटेज उतना ज्यादा बढ़ जाएगा. यहाँ पे बोलता है आप एक्सक्लूड कर दो, सिट भी बोलता है एक्सक्लूड करो, बिकॉज लिक्विडेटर वाज not doing anything for 15 months. He has not done anything. Blame game has started. Now come to here. He has referred to his letter 13th November addressed to the liquidator, by which he stated the intention to realize the security interest on property of the which was mortgaged to the SIDBI, and also requested the liquidator to advise him about the formalities involved in the process of the realization. तो उसने बोला what as SIDBI said that I will realize the property, I will sell the property, है ना? You just tell me the process कि क्या उसका process क्या है? He argued that instead of handing over the possession of the said property to the appellant to enable him to sell the property, the liquidator published an auction notice in the newspaper auctioning the assets on 15th February 2019, whereupon the appellants requested the respondent to cancel the e-auction while his letter dated so and so, whereafter he communicated the price at which appellant wanted to dispose of the said Bawal property. Bawal property is the land. He has further submitted that liquidator first asked for an undertaking from the appellant and later filed an application before adjudicating authority seeking direction to respondent to submit an undertaking to the liquidator and also requiring the appellant to intimate the time by which he will be able to sell the property. See, liquidator ने उनको letter लिखा, he said कि भाई आप हमें undertaking दो that you will sell the property and the timeline of the sale of the property. Everything you must disclose. He has argued that there was no reason for the liquidator to ask for an undertaking from the SIDBI, and the clarification of the issue was given by the AA, but the liquidator still did not hand over the said property to the SIDBI for realization. The learned counsel for the appellant has argued that thus there was a delay in completing the liquidation process, which was attributable to the liquidator and his action/inaction therein, and therefore the benefit of exclusion of approximately 15 months.
सर
हाँ.
सर एक चीज मैं ये पूछना चाहता हूँ, अगर माना वो नहीं मानते हैं कि साहब हम फीस नहीं बढ़ा सकते हैं क्योंकि
सर एक मिनट सतीश जी आई विल कम टू योर क्वेश्चन जस्ट आफ्टर फिनिशिंग दिस. बस इसको मैं जल्दी से फिनिश करूंगा, देन आई विल कम टू योर क्वेश्चन. हाँ, एक मिनट आप अपना नोट करके रखिए. शुड नॉट हैव बीन लर्नेड काउंसिल learned counsel for the appellant refer multiple emails every closure of the liquidator but want to cooperation from the liquidator. It could not be done. The learned counsel for the respondent here liquidator submitted the argument bringing to our attention the list of dates and events filed by the liquidators to show how the liquidator has been diligent and careful. Whenever you file for application for exclusion period, you must write list of dates and events so that NCLT will be convinced about your action during the given period of exclusion. Okay? So he has written the list of dates and events to show how the liquidator has been diligent and careful about the following the process of the liquidation, and in particular the disposal of HSIDC property. But due to multiple issues being raised by the SIDBI from time to time, he had to approach NCLT after due discussion with direction to carry out the liquidation process forward. Elaborating on the events, he has submitted that after the appellant had informed him that it intended to realize its security interest in the property Bawalpatti, he sent an email 27th February apprising the appellant that in order to realize the security interest in terms of section 52, the appellant has to intimate the price at which it proposes to realize the secured asset in terms of regulation 37. Liquidator sent an email apprising the appellant SIDBI कि भाई आप अपना जो प्राइस है किस प्राइस पे आप रियलाइज करना चाहते हैं एज पर रेगुलेशन 37. He has argued that reminder the appellant intimated the reserve price as 3.6 crore on 8/3/19, where after the liquidator asked for an undertaking from the appellant that it would provide the property to the buyers in case person willing to purchase the property for an amount more than the reserve price is identified by the liquidator. He has further argued that appellant refused to submit the said undertaking, maintaining that no such undertaking is necessary. See, he was very adamant. The SIDBI was very adamant that he refused to give any undertaking, whereas IBC said, yes, you must take undertaking. And since there was a stalemate, the liquidator filed an application so-and-so before NCLT seeking direction to the appellant to submit the requisite undertaking. He further submitted that the after SIDBI submitted affidavit reply, pleadings completed, then he has stated that thereafter liquidator sought a meeting with the appellant to finalize the certain issues to maintain transparency and governance standard in accordance with the liquidation process. I'm just coming to concluding part here. See, liquidator is relying upon regulation 37. So I'm just coming to regulation 37, which has been reproduced in this judgment. Regulation 37, realization of security interest by the secured creditors. A secured creditor who seeks to realize its security interest under section 52 shall intimate the liquidator of the price at which he proposes to realize its secured assets. See, it was duty bound. It was duty of the SIDBI to intimate to the liquidator. Liquidator asked, SIDBI refused. Liquidator asked to give undertaking, SIDBI refused. Liquidator shall inform the secured creditor within 21 days of receipt of intimation under section. If a person is willing to buy the secured asset before the expiry of 30 days from the date of intimation under subsection 1 at a price higher than the price intimated under subsection 1. After receipt of email, SIDBI communicated to liquidator estimated price 3.6 crore at which it wished to realize its security interest in Bawal property. We now examine the contention of the learned counsel for the liquidator. SIDBI could not understand or interpret the regulation 21A, which is regarding the presumption of security interest. The relevant portion of 21A. Presumption of security interest. A secured creditor shall inform the liquidator of its decision to relinquish its security interest to the liquidator state or realize its security interest as the case may be in Form C or Form D of the Schedule 2, provided that where the secured creditor does not intimate its decision within 30 days. You are right. So it is 30 days. from the liquidation commencement date, the assets covered under the security interest shall be presumed to be part of liquidation estate. Where security creditor proceed to realize the security interest, it shall pay. So if liquidator realize, then it will pay the realized amount, distribute among the secured creditors, and exceed amount will be
Probably the
sorry, here
wages of the workmen.
Sorry. Here I am sorry. Where a secured creditor proceed to realize, मतलब अगर secured creditor take decision that I will realize these assets, then he will sell it and he will retain the his part, and less exceed amount will be refunded to the liquidator, and cost of the realized amount also. Cost of the liquidation process. Now I am just coming to concluding part. It is clear from the regulation 21, the liquidation process requires that after presumption of the security interest by the security, the security creditor shall pay as much as toward the amount payable under so and so. It would have shared in case it had relinquished the security interest to the liquidator within the 90 days from the liquidation commencement date. Quite obviously, this was not done by the appellant, as it is evident from the order dated so and so, by which appellant was directed at a much later date to pay its share of liquidation fees and cost after detailed calculation have been provided to it by the liquidator. So liquidator has given all details about the fees and all these things, but he did not respond. We also look at the issue of the liquidator seeking an undertaking from the appellant. A perusal of the email sent by the liquidator 9/3/19 asking for an undertaking prior to the release of the security, and namely SSID. Reminder email was also there. Liquidator only not keeping with the requirement of the liquidation process regulation. Now come to on the basis of detailed discussion in the above paragraph, it becomes abundantly clear that resolution process was following the procedure as set out in the liquidation process regulation with regard to disposal of the security, including SSID bowel property, in which SIDBI has expressed its intent to realize its security interest. It also becomes clear that due to misinterpretation and lack of proper understanding of the procedure, SIDBI was unable to follow the requirement as was being communicated to him by the liquidator. Hence, the liquidator had to approach the AA thrice. Liquidator approached NCLT thrice, not once, not twice, but thrice. How liquidator is active here? In the course of liquidation to seek necessary direction qua the appellant. We also find that such difficulties being faced by the liquidator were being brought to the knowledge of the stakeholders SEC, and necessary direction for further action were being obtained by the liquidator. Liquidator also brought all these problem before the SEC. We note that this tribunal has held that even if the secured creditor proceed to realize its security interest, it is liable to pay the fees of the contemplated under regulation 20. So secured creditor, if realize its assets from its own, he is liable to pay the fees of the liquidator. It thus becomes quite clear that compliance of regulation so and so and section 52 are absolutely necessary, even if secured creditors proceed to realize its security. So the SIDBI was taking all these things very casual, not willing to give any undertaking, not willing to pay fees of the liquidator, all these things. We thus find that liquidator has carried out his responsibility with due diligence and without any prejudice to the appellant. See, the appreciation, you must have seen many stricture against the RP or liquidator, but here the appreciation wordings have been given by the enclave in favor for the liquidator. How liquidator was diligent without any prejudice to appellant or any other stakeholder, and therefore cannot be held responsible for delay that has taken place in pursuing the liquidation of the CD. Therefore, we come to the conclusion that AA has not committed any error in excluding period from 13/11/18 to 2020, 24th February 22 from the liquidation process for calculation of liquidator's fee slab under Regulation 4 of the Liquidation Process Regulation. Being devoid of merits, the appeal is dismissed. There is no cost. So law helped to diligent person. Liquidator was able to get the order in his favor. Liquidator was able to get his appropriate fees, reasonable fees, or agreed fees, despite the many hurdles created by the SIDBI. Yes, Joshi ji, please ask me your question. I think he is not there.
हेलो, हाँ जी सर।
हाँ बोलिए प्लीज।
हाँ, मैं ये कह रहा हूँ कि अगर माना एससीसी तैयार नहीं होती है हमारी बात कहने के लिए, तो हम उनको मतलब प्रेशर टैक्टिक्स तो दोनों तरफ से होती है कि क्योंकि एडवांस स्टेज पे लिक्विडेशन पहुंच चुका है, तो हम उनसे कह सकते हैं कि ठीक है आप अप्लाई कर दीजिए लिक्विडेटर चेंज करने के लिए, हम यहीं पे कंक्लूड करते हैं।
आप चाहते क्या है पहले ये बताएं, व्हाट यू वांट?
हम तो चाहते हैं जारी रखना, पर कहने का मतलब है कि अगर माना वो तैयार नहीं होते, क्या उस स्टेज पे हम
नहीं,
उनसे
अगर आप लिक्विडेटर बन के कंटिन्यू रहना चाहते हैं, देन यू अप्रोच टू एनसीएलटी।
ठीक है।
and put your grievance before NCLT. See, the same case, the similar case was faced by another liquidator, and he was willing to quit from the liquidation process, and he approached this SCC, everything, they were refusing that no, you continue with this liquidation process. Then liquidator approached me, I filed an application before NCLT, and I said, my lord, liquidator wants to quit, SCC is refusing, but he has fundamental right to quit this liquidator, even if law is silent. Now there is an amendment in regulation that with the consent of the SCC or with the consent of the COC, RP can quit. Am I right? There is an amendment in 2003. But SCC refused. Despite so, I got order in favor of the liquidator, and liquidator absolved from the liquidation process, and new liquidator was appointed. So even we can go beyond because nobody can be like liquidator is not a bonded labor. You cannot compel him to continue with the liquidation process. We have being a citizen of India, we have fundamental right under the Constitution of India. And Constitution of India is the mother law. IBC, regulation, all these things are son and daughter. Son and daughter cannot override the mother law.
बट आजकल बच्चे बात कहाँ में कहना मानते हैं माँ बाप का?
बच्चे नहीं मानते हैं, लेकिन जो कोर्ट है वो तो मानते हैं। बच्चे ना माने कोई बात नहीं, बच्चे
आप कहते
कोर्ट तो मानेगी ना। हम तो कोर्ट की बात कर रहे हैं कि कोर्ट को हमने मनवाया और कोर्ट हमारे फेवर में ऑर्डर पास किया और लिक्विडेटर को चेंज किया। यहाँ आप चाहते हैं यू कंटिन्यू विद द लिक्विडेशन प्रोसेस। आप इसका पूरा अपना पूरा उसका बेस तैयार करिए, ग्राउंड तैयार करिए कि आप क्या क्या चाहते हैं, उसके लिए आपको क्या क्या स्टेप्स लेना है ना। तो आप उसका ग्राउंड सारा तैयार कर लीजिए, एससीसी के सामने रखिए। एससीसी वंस एससीसी रिफ्यूज, देन यू अप्रोच टू एनसीएलटी, है ना। एंड एससीसी रिकमेंडेशन इज नॉट बाइंडिंग अपॉन द लिक्विडेटर। देयर इज अ रिसेंट जजमेंट ऑफ दिस ऑनरेबल सुप्रीम कोर्ट।
हमारे वाले केस में क्योंकि कोई एसेट की रिकवरी नहीं होनी, बहुत नॉमिनल सी एसेट की रिकवरी होनी है, तो अब यहाँ पर बात ये आती है कि यदि हम उनके सामने पुट अप भी करें कि ये एक एवरेज मंथली रेट है, उस मंथली रेट का क्या आपको क्या लगता है कि क्या एक रीजनेबल रेट है जो मंथली रेट जो प्रैक्टिस में है, क्या वो सजेस्ट कर सकते हैं?
आई एम नॉट गोइंग इनटू द क्वांटम ऑफ द फीस और रेट और दिस परसेंटेज ऑफ फीस। आपको जो भी रीजनेबल लगता है अपने फेवर में कि हाँ यू आर डूइंग द वर्क एज ए लिक्विडेटर, यू आर एंटाइटल्ड फॉर द फीस। लिक्विडेशन स्टेट भले जीरो हो, कंपनी का रिस्पॉन्सिबिलिटी सारा आपके पास है, यू आर रिस्पॉन्सिबल पर्सन। and
Sir,
you are entitled for the fees.
I just want to use your experience in this regard, that what are the normal practice in regard to the fees if suppose a person claiming on per monthly basis, this is how one can explore. This is my submission.
First you put up your proposal before SCC. Let SCC decide, and while putting all this proposal, you should also explain the quantum of volume of works involved, responsibility involves, and the time involves. Everything you have to explain so that you can convince the SCC, and then SCC will decide what will be the fees. If SCC still refuse, then approach to NCLT, incorporate all these things in the minutes. You should also incorporate all these things in the minutes and approach to NCLT. My lord, this is the status, and the company is having very insignificant assets. So, being a liquidator, either SCC pass, either NCLT pass the order for X amount, or I will quit. जो भी आपको whatever you want, आप अपना grievance, अपना relief जो भी चाहते हैं, आपका prayer में हो, सीधा सीधा. ठीक है?
ओके जी, ओके.
मेरा
सर, आई हैव अ स्मॉल डाउट सर.
आपको मैंने अपना नंबर भी दे दिया. इफ यू वांट फर्दर डिस्कशन, आप मेरे को फिर भी कॉल कर सकते हो. मैं अपना नंबर दिया था.